Today on Bench Briefs, we're looking at a landmark decision from the Supreme Court of Canada that tackles the delicate balance between law enforcement powers and the protection of individual rights under the Charter. In R.V. Jacques-Taylor, the court wrestled with important questions about search and seizure procedures and what happens when those procedures are challenged as unconstitutional. So, what's this case all about? At its core, it involves Mr. Jacques-Taylor, who was subjected to a search by police officers. During that search, the officers found evidence that was later used against him in criminal proceedings. But Mr. Jacques-Taylor argued that the search was not just unfair. He said it violated his charter rights, specifically Section 8, which protects Canadians from unreasonable search and seizure. He claimed that the way the search was conducted didn't follow the rules set out by the criminal code and that his rights had been infringed. Let's break down the facts a little more. Jacques-Taylor was stopped by police and they proceeded to search him and his belongings. The search yielded evidence that became central to the criminal charges he faced. However, Jacques-Taylor challenged the validity of the search itself, arguing that the police did not have proper authority or that the procedures they followed were flawed. This raised a big question. Was the search reasonable under the Charter? If it wasn't, then the evidence gathered could be considered fruit of the poisonous tree and potentially excluded from the trial. The legal issues before the Supreme Court were twofold. First, did the search violate Section 8 of the Canadian Charter of Rights and Freedoms? Section 8 is crucial because it guarantees that everyone is secure against unreasonable search or seizure, which means the police must follow strict rules to justify any intrusion. The court needed to decide whether the police actions in this case met those standards. Second, if the court found the search was unconstitutional, the next question was whether the evidence obtained should be excluded under Section 24(2) of the Charter. This section guides courts on whether admitting evidence obtained through a charter breach would bring the administration of justice into disrepute. It's a balancing act. Courts weigh the seriousness of the violation against the importance of the evidence to the case. Finally, the court also examined the constitutionality of the criminal code provisions that set out the search procedures. This is significant because if those provisions themselves are unconstitutional, it could have broad implications for how police conduct searches across the country. Why does this case matter? Well, search and seizure law is one of the most frequently litigated areas of charter rights. Police need tools to investigate crimes effectively, but Canadians expect those tools to be used lawfully and respectfully. The Supreme Court's decision in Jacques-Taylor clarifies the limits of police powers and reinforces protections for individuals against overreach. It also sends a message about the importance of following proper procedures, not just for the sake of the law, but to maintain public confidence in the justice system. This decision will likely impact not only future cases involving contested searches, but also how police officers are trained and how search laws are interpreted going forward. It reminds us that the Charter is a living document, continuously shaping the balance between collective security and individual freedoms. Thanks for listening to Bench Briefs. Be sure to join us next time for another deep dive into a case that's shaping Canadian law. Until then, take care.